Can the U.S. government really strip your citizenship for something you did years after you became a citizen? Could a small fraud conviction suddenly turn a U.S. passport into a temporary privilege instead of a permanent status? And could this apply retroactively to things that happened back in the late 90s? A new bill in Congress called the Fraud Accountability Act is trying to do exactly that. You're watching Immigration Updates Hub. In this video, I'm going to break down what this bill actually says, how it tries to expand denaturalization, who it could apply to, why so many people are scared, and just as important, why it is still far from becoming law and faces serious legal problems. Let's start with the basic question that has everyone on edge. Is the government trying to expand the pool of people who can be denaturalized? The short answer is yes, this bill absolutely tries to do that. The longer answer is that what's written in a bill, what can realistically pass Congress, and what can survive in court are three very different things. My goal is to walk you through all three levels so you understand the real risk, without drowning in fear from social media. The Fraud Accountability Act has been introduced in both the Senate and the House. It's largely a political reaction to a recent, high-profile daycare fraud scandal, where people allegedly stole a lot of money while also having immigration ties. Whenever there's a big scandal like that, politicians feel pressure to do something. One of the easiest things to propose is harsher immigration consequences because that plays well with certain voters. That's the political context behind this bill. Now, what does it actually do in terms of denaturalization? Under current law, denaturalization in the United States is tightly limited. Generally, you can only be denaturalized if 1. You illegally obtained citizenship in the first place. For example, there was some legal requirement you did not actually meet, but it was missed at the time. 2. You committed a fraud or willful misrepresentation during the naturalization process or in earlier immigration processes that directly led to your citizenship. In other words, present law focuses on what happened before and while you were becoming a citizen. If the government later proves you lied about something important, like a serious crime, a previous deportation, a fake identity, then they can go to civil court and ask a judge to cancel your naturalization. That is denaturalization. Crimes committed after you become a citizen are handled through the town criminal justice system. You can be arrested, tried, convicted, fined, imprisoned. But your citizenship itself is not supposed to be the punishment. You're punished like any other citizen would be. The Fraud Accountability Act tries to change that in a very fundamental way. It would allow, and in some situations require, denaturalization as a direct punishment. For certain fraud convictions that happen after you became a citizen, that's a huge shift. It moves denaturalization from being about you never qualified in the first place into we are taking citizenship away because of something you did later. How does the bill do this technically? Right now, most denaturalization cases are handled as civil lawsuits, usually brought by the Department of Justice in federal court, separate from any criminal case. The standard is high and the process is independent. The Fraud Accountability Act would basically plug denaturalization directly into the criminal court. That convicts you of fraud. Under the bill's language, if a naturalized U.S. citizen is convicted of a qualifying fraud offense, the same criminal court would be required to immediately move forward with denaturalization as part of that proceeding. The text reportedly uses mandatory language, something like, the judge shall denaturalize. That shall is crucial. It means the judge is not being given discretion to say, this is a minor case. I don't think denaturalization is appropriate here. If the elements in the statute are met, the judge is forced to strip citizenship. The bill does something else that has major immigration consequences beyond citizens. It removes the $10,000 threshold that currently applies to many immigration-related fraud definitions. Under today's law, for a fraud offense to be treated as an aggravated felony. In the immigration context under INA paragraph 101A 43M, the loss to the victim or victims generally needs to be at least $10,000. That threshold is important because aggravated felonies can trigger deportation for permanent residents and block many forms of relief. By removing that $10,000 threshold and simply saying fraud, the bill would allow any fraud offense, big or small, to become a trigger. For permanent residents, that could mean deportability for relatively minor frauds that never would have counted as aggravated felonies before. For naturalized citizens, the bill would tie any fraud conviction, not just large-scale fraud, to mandatory denaturalization. Another key move in the bill is that it rewrites and reuses the deportability section of the Immigration and Nationality Act, INA Paragraph 237A2, which traditionally applies only to non-citizens, green card holders, people in other statuses, and those without status. Deportability is the concept used to say you can be removed from the United States because of this offense. Naturalized U.S. citizens are not supposed to be in that category at all. By definition, you cannot deport a citizen. What this bill does, as described, is essentially borrow those deportability definitions and plug them into a denaturalization framework. It says, in effect, if you, a naturalized U.S. citizen, commit a fraud offense that would make a non-citizen deportable, then that fraud can also be used to denaturalize you. Once you're denaturalized, you're no longer a citizen, so then those same grounds can be used to actually deport you, just like any other non-citizen. This is legally and conceptually radical because it blurs the line between citizen and non-citizen in a way U.S. law has historically refused to do. Up to now, the basic rule has been simple. Non-citizens can be deported, citizens cannot. Denaturalization, when it happens, is about correcting a past error or fraud in the process of obtaining citizenship, not about punishing post-citizenship conduct. On top of all that, the bill has a retroactive USCIS component that is alarming on its face. The text, as described, would apply back to September 30th, 1996. That means the government could potentially use this law, if it ever passed, against people who were convicted of fraud at any time since late 1996, almost your 30 years of history. So imagine, someone became a citizen in 2000, committed a relatively small fraud offense in 2005, served their sentence, rebuilt their life, and has been a citizen in good standing for nearly 2 decades. Under the bill's logic, that old fraud, if it fits the definition, could suddenly become a basis to strip their citizenship now. That's why this proposal has hit such a nerve. It feels like it turns citizenship into something that's always hanging by a thread for naturalized people. Now, before we let the anxiety run away completely, we need to step back and remember a crucial point. This is a bill, not a law. In the U.S. system, thousands of bills are introduced in Congress. The overwhelming majority never become law. Being introduced is step one in a long process. Committee discussions, possible amendments, votes in each chamber, reconciliation, and then the president's signature. At every stage, most controversial ideas die or get heavily watered down. Right now, the Fraud Accountability Act is essentially at the discussion stage. It has been introduced. Lawmakers are using it to signal they are tough on fraud. But introduction is not the same as enactment, and even if some version of it moved forward, it could be changed significantly along the way. Beyond the politics, there are serious legal and constitutional problems with the bill as described. The first big one comes from a Supreme Court case called Afroyim v. Rusk, 1967. In that case, the Supreme Court held that Congress cannot take away U.S. citizenship from someone who has it, unless that person voluntarily gives it up, through things like formally renouncing citizenship. The court treated citizenship as a constitutional right protected by the 14th Amendment, not a benefit that Congress can revoke whenever it wants. What the Fraud Accountability Act tries to do is exactly what Afroyim warns against. It creates new mechanisms for Congress, through statute, to take away citizenship as a consequence of certain behavior, without any voluntary renunciation by the citizen. That doesn't mean Congress can't try, but it does mean that if this bill ever became law, it would face a direct constitutional challenge under Afroyim. Courts would have to decide whether this kind of denaturalization for post-citizenship crimes is consistent with the Supreme Court's understanding of citizenship as a protected constitutional status. The second major legal problem comes from another important Supreme Court case, Schneider v. Rusk, 1964. In Schneider, the court made it very clear that naturalized U.S. citizens must be treated the same as natural-born U.S. citizens. In terms of their rights and protections, with one narrow exception, only natural-born citizens can be president. Aside from that, the court said, once you are a citizen, whether by birth or naturalization, you are a citizen, period. By creating a system where naturalized citizens can be stripped of citizenship for fraud committed after naturalization, while natural-born citizens cannot, the bill effectively creates 2 classes of citizens. natural-born citizens who can commit fraud, even very large fraud, and face criminal punishment, but never lose citizenship. Naturalized citizens who can commit fraud, potentially even relatively minor fraud, and face not just criminal punishment, but also loss of citizenships and possible deportation. That is the very definition of a second-class citizenship. It makes naturalized citizenship in Ursam conditional, LAM, something you can lose later, while natural-born citizenship remains secure. That kind of unequal treatment based purely on how you became a citizen runs straight into the equal protection principles that Schneider v. Rusk emphasized. So again, even if this bill were to pass Congress, which is already a big if, there is every reason to expect immediate constitutional challenges. Lawyers would argue that it violates Afroyim by taking away citizenship without voluntary renunciation, and violates Schneider by creating two unequal classes of citizens. There are also other possible arguments: due process concerns, ex post facto type arguments about retroactive punishment, and Eighth Amendment concerns if denaturalization is seen as a form of cruel or excessive punishment when stacked on top of criminal penalties. Here is my honest assessment. As written, this bill is legally very shaky. Courts have repeatedly made clear that citizenship is not to be treated like just another immigration status you can upgrade or downgrade. They have also made clear that naturalized citizens stand shoulder to shoulder with natural-born citizens in terms of constitutional protection. The Fraud Accountability Act tries to push hard against both of those ideas at once. That doesn't mean it isn't scary. It is scary that lawmakers are even thinking in these terms, using denaturalization as a punishment tool, instead of a way to correct fraud in how citizenship was obtained. It's also concerning that the bill appears to treat any fraud, even below the old $10,000 threshold, as enough to trigger life-altering immigration consequences. There is a real and justified worry that smaller, less sophisticated defendants, people who pled guilty without fully understanding the immigration impact, could be crushed by a law like this. But anxiety works differently from risk. Anxiety goes up the moment you hear new bill or denaturalization, even if the legal reality is that this particular bill is unlikely to survive in its current form. That's why it's so important to separate your emotional reaction from the actual legal posture. So, what does this mean practically if you are a naturalized U.S. citizen or a permanent resident? First, if you are a citizen who obtained your citizenship honestly, this bill does not rewrite your past. It doesn't suddenly mean there was something wrong with your naturalization. What it would potentially do is attach new consequences to certain future or past fraud convictions. That's still serious, but it's a narrower group than all naturalized citizens. Second, if you are a permanent resident, remember that immigration consequences for CASAD fraud have always existed. The $10,000 aggravated felony threshold has given some people breathing room on smaller fraud cases. But even without that, some fraud convictions can already cause problems under existing grounds of removability, like crimes involving moral turpitude. This bill would certainly make the landscape harsher by removing the monetary threshold, but it doesn't invent the concept of fraud can affect your status. That concept is already there. Third, and this is critical, this video is not legal advice. If you have ever been charged with or convicted of fraud, or you are being investigated for any kind of financial or benefits-related offense, you should speak to a qualified immigration attorney and, ideally, a criminal defense attorney who understands immigration consequences. Do not rely on social media summaries, whether they are panicked or overly reassuring, for your personal situation. On the emotional side, it is completely understandable that naturalized citizens feel targeted when they hear about bills like this. You may have spent years, even decades, doing everything by the book. You waited for a priority date to become current. You went through background checks, interviews, biometrics, the civics exam, the oath, to then see politicians treating your citizenship as something that can be taken away in a sentencing hearing feels like a betrayal. It can help to remember a few things. A bill's introduction is often more about politics and messaging than about real enforceable law. The U.S. legal system has strong precedent that protects citizens from exactly the kind of second-class status this bill would create. Denaturalization, even under current law, remains extremely rare and heavily litigated. The government already has tools to punish fraud, prison time, fines, restitution, without needing to take citizenship away. Courts know that. From a bigger picture perspective, what worries many immigration lawyers and advocates is the trend: more conversations about using immigration status, even citizenship, as a punishment for criminal behavior. Deportation has long been a consequence for non-citizens who commit certain offenses. Extending a similar logic to citizens via denaturalization shifts the ground under the entire idea of what it means to finally belong. That's why it's important for people who care about these issues to stay informed, to understand the difference between existing law and proposed changes, and to participate in the democratic process by voting, by contacting legislators, by supporting organizations that defend immigrants' rights. To summarize the key points for you calmly and clearly, the Fraud Accountability Act is a proposed bill, not a law. It is in the early stages and may never pass. The bill would expand denaturalization to include fraud committed after denaturalization, turning it into a form of punishment. It would remove the 10,000 fraud threshold, meaning even smaller fraud cases could have major immigration consequences for permanent residents and naturalized citizens. It would effectively apply certain deportability concepts to citizens by using them as triggers for denaturalization. It claims to apply retroactively back to 1996, potentially reaching convictions that are decades old. The bill faces serious constitutional problems, especially under Afroyim vs. Rusk and Schneider vs. Rusk, which protect citizenship from arbitrary loss and forbid creating second-class citizens. Because of those problems, even if it passed, it would likely face immediate, strong legal challenges. If you are feeling overwhelmed, take a breath and remember, feeling fear does not mean you are in immediate danger. It means you care about your status and your family's future. The best response is not panic, it's information and action where appropriate. If this explanation from Immigration Updates Hub helped you understand the Fraud Accountability Act and the current denaturalization debate, consider sharing it with others who are worried and might be reading scary headlines without context. And if you have specific concerns about your own history, talk to a qualified immigration attorney who can look at your individual case. You've worked hard to build your life here. You deserve clarity, not confusion, facts, not fear. Stay informed, stay grounded, and take things one step at a time.